We're going to go ahead and get started. Good afternoon. Welcome to our event. This event is actually being co-sponsored by 4 groups, not just the Federalist Society. I want to thank Nyla and Ashley from the ACS. I want to thank Caitlin from Christian Legal Society, and of course I want to thank Jennifer from OutLaws. The 4 of us have come together to turn this event on for you guys, and of course the food and things are sponsored by all the groups. This event is the Christian Legal Society versus Martinez case decision. Of course, my name is Man Sharma. I'm the president of the Federalist Society. It's my pleasure to welcome you to this event. I'm going to give a quick, explanation of the debate format for some of you who have not been to our events before. The debate format we have usually allows for, we don't, pull people off stage if they go a little bit over the time. A 12-minute introduction for each speaker, and then we go to a 10-minute rebuttal for each speaker, and finally, with time left, we allow for questions from the audience. Following that, that's the conclusion of our event. This is actually the last event for the Federalist Society this semester. But I do want to thank you guys for coming out to our events. We've had a great turnout, and we're going to have another high-energy semester coming up for you guys in January. So with that, I'll get started with a brief biography of each of our speakers today, and then we'll go ahead and get started. Professor David Goldberger is the Isidore and Ida Topper Professor Emeritus of Law here at Ohio State. He joined the Ohio State faculty in 1980 after serving as legal and legislative director of the Illinois Division of the ACLU. He teaches classes on common law and civil liberties. He earned his BA and JD at the University of Chicago, like many of our speakers this year. Prior to working at the ACLU, Professor Goldberger was a staff attorney for the Legal Assistance Foundation of Chicago, specializing in law reform legislation. Professor Goldberger has also argued several times before the United States Supreme Court. In 1977, he won his first case in National Socialist Party of America versus Village of Skokie. The case obliged state courts to provide expeditious review of injunctions against public assemblies. And in 1995, he argued the case McIntyre versus Ohio Elections Commission. The court's ruling in that case invalidated an Ohio statute prohibiting distribution of anonymous, non-libelous campaign literature. Also in 1995, Professor Goldberger was co-counsel in Capital Square Review and advisory board versus Panet. And in 2005, Professor Goldberger argued before the U.S. Supreme Court in the case of Carter versus Wilkinson. He won that case, and it upheld a federal statute protecting the right of prison inmates to freedom of religion. His research and writing focus on free speech decisions of the United States Supreme Court have been highly influential. He continues to research in areas of civil liberties cases, and he works on behalf of clients nowadays unable to afford counsel otherwise. Before becoming an emeritus professor, I do want to mention that Professor Goldberger was a longtime faculty advisor of ours at the Federalist Society, and he gets our sincere thanks for that. He's been a pillar of strength for this group for many years. Daniel Tokaji is the professor of law at the Ohio State University's the associate director of the election law Lawrence program, and he's a professor of law here, of course. His areas of expertise include election law, civil rights, and federal courts. His scholarship addresses questions of political equality, racial justice, and the role of the judiciary in democracy. He's a co-author of the casebook on election law, Cases and Materials. His scholarship has also appeared in Michigan Law Review, Stanford Law and Policy Review, and the Yale Law Journal. He's the author of the Equal Vote Blog, which provides commentary on election reform and voting rights issues. He's a faculty advisor to the ACS here at Moritz, and is active with the ACLU of Ohio, the Lawyers Committee for Civil Rights, and the Conference of Asian Pacific American Law Faculty. Prior to coming to Moritz, Professor Tokaji was an attorney for the ACLU Foundation of Southern California from 1995 to 2003. He clerked for the Honorable Justice Stephen Reinhardt of the U.S. Court of Appeals for the Ninth Circuit. He earned his JD from Yale Law School, where he was the editor of the Yale Law Journal and the director of Disability Law Clinic. He graduated summa cum laude from Harvard Law College in '89 with an AC in English, American Literature, and Philosophy. And with that, I'll go ahead and turn it over to our speakers, and we'll get started with our event. Thanks.
Well, thank you so much. Thanks to the 4 groups who are sponsoring this event. Thanks to all you who are coming. And most of all, I want to thank my friend and colleague, Professor Goldberger, for agreeing to do this debate. He and I have been talking about this issue on and off, I guess now for 6 years or so. And it is always a pleasure to discuss and debate First Amendment issues with someone who is a real hero of free speech for reasons that are too voluminous to go into here. So we're talking today about this case that the Supreme Court of the United States decided in June of this year, Christian Legal Society versus Martinez. In that case, the Supreme Court upheld UC Hastings Law School's registered student organization policy. This is a policy that prohibited school-sponsored groups from discriminating on various bases, including race, sex, religion, and sexual orientation. And specifically in this case, a majority of the Supreme Court rejected CLS's argument that UC Hastings was discriminating based on viewpoint by requiring that student groups have open access to all Hastings students, regardless of their status or beliefs. Now, I believe that this decision was correct and will defend its rationale. The conventional way of viewing this basic issue is as a conflict between equality and speech. On the one hand, between the idea of equal access for all students regardless of their status or beliefs. On the other hand, freedom of speech or freedom of association, the ability of a group to exclude people whom it believes harmful to the delivery of its message. Now, I believe that this conventional way of looking at the case is perhaps not exactly wrong, but overly simplistic. As I shall try to explain, I think there are mingled speech and equality interests on both sides of this case. I further think that in upholding Hastings' anti-discrimination policy for state-subsidized student groups, the court was promoting the value of equality in the realm of speech, and by doing so, promoting the objective of providing a forum for robust public debate on campus, and more broadly, for promoting a robust democracy. I'm going to focus on the particulars of this case in the remarks that will follow, but as most of you probably know, we had a similar controversy erupt here at the Moritz College of Law and Ohio State University several years ago, the product of which is a policy which I think to be problematic, and so I will say a few words about the Ohio State University's current policy in closing. So let me introduce the case, which I'm sure most of you have not read, by giving you its basic facts. UC Hastings is part of the University of California system, therefore a state actor for constitutional purposes and bound by the requirements of the Constitution, including the First Amendment. UC Hastings, like many law schools, public and private, officially recognizes certain student organizations and provides them funding, provided that they abide by certain rules. One of those rules is that they avoid discrimination, and specifically that they not discriminate on certain designated bases, including race, color, religion, national origin, ancestry, disability, age, sex, or sexual orientation. Now, the parties in the case stipulated, and this turns out to be important to the result, that this was an all-comers policy, meaning that student organizations were not free to discriminate based on their status or beliefs. One group, the Christian Legal Society, refused to abide by this policy in the 2004 academic year. And consistent with its non-discrimination policy for school sponsored student organizations, Hastings refused to grant CLS official recognition with its attendant benefits, including eligibility for school funding. CLS members were, of course, free to organize on their own. Hastings offered to provide CLS with free meeting space. Thus, Hastings did nothing to suppress CLS's speech or association activities, but as the court notes, it declined to subsidize those activities as long as CLS insisted on discriminating on the basis of belief as well as sexual orientation. Now, on the facts that were presented to the Supreme Court, personally, I don't think this is a terribly difficult case. The majority, per Justice Ginsburg, notes that by recognizing and subsidizing student organizations, UC Hastings was creating what we call in First Amendment law a limited public forum. And what that means is that the state, in this case UC Hastings, has some ability to define the speech that can take place within it. What it can't do under a case called Rosenberger versus University of Virginia, what it can't do is to discriminate based on viewpoint. So the question before the court was whether this all-comers policy of UC Hastings prohibiting discrimination based on status or belief was viewpoint neutral, or alternatively, whether it discriminated based on viewpoint. Now, here's something that is very important to emphasize about this case, which sometimes gets lost. This is very different from a state imposing an outright prohibition on private groups that choose to discriminate in their membership. An example of such a case is a case decided a few years back, Boy Scouts versus Dale. There was a New Jersey law that prohibited certain private groups from discriminating on the basis of sexual orientation. The Supreme Court struck that down. So the state can't compel a private group to include unwanted members, including gays and lesbians. That much is clear. The question before the court in the CLS case is whether the state is required to subsidize groups that insist on discriminating. So was this viewpoint discrimination? The court, rightly in my opinion, concludes that it is not. The policy wasn't facially discriminatory, nor was it intended to discriminate against religious groups. Now, the intent point is, to my mind, the big bone of contention between the 5 justices in the majority and the 4 justices in dissent. I'll come back to this in a moment. What the court, in an opinion written by Justice Ginsburg, joined by 4 other justices, including 3 other justices, I should have said, no, 4 other justices joined the opinion, including Justice Kennedy. What the court concludes is that Hastings' non-discrimination policy was not viewpoint discriminatory. You know, I'm not generally a big fan of Justice Kennedy. As some of you who've taken my classes before may be aware. But I have to tip my hat to him in this case. He wrote a concurring opinion, which I think does a very nice job of explaining the purpose that is served by UC Hastings policy. Here's what Justice Kennedy in his concurring opinion has to say. Law students come from many backgrounds and have but 3 years to meet each other and develop their skills. They do so by participating in a community that teaches them how to create arguments in a convincing, rational, and respectful manner, and to express doubt and disagreement in a professional way. A law school furthers these objectives by allowing broad diversity in registered student organizations, but these objectives may be better achieved if students can act cooperatively to learn from